we are going to talk about POSH law today. So the session flow will be obviously talking about introduction of the law, need of gender sensitization, definitions under the law, redressal mechanism, that is if a complaint comes to the company, how it is to be addressed, what is the process to be followed, and then obviously we'll take a few questions at the end. In between, if you have any questions, you can raise your hand in the meeting or you can unmute yourself and talk. But please make sure that after you finish talking, you please mute yourself so that the session doesn't get disturbed. So let's start. The name of the law is Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. This law came into existence in 2013. It's been 10 years since the law is implemented in India. Before that, there were a few guidelines given, or obviously there were punishments under IPC, under Indian Penal Code, criminal offences. But this specific law related to this specific requirement was not there before 2013. So like the name says, there are three major components of POSH law. First is prevention. Prevention means making people aware about women's safety, how the work environment should be for the women, and all these things, security of women. Second thing is prohibition, how the sexual harassment of women at workplace can be prohibited or can be limited, or how gender sensitization can be used to prohibit such kind of incidences at workplace. And third major important part is if sexual harassment happens, what is the redressal mechanism, what is the process that needs to be followed by the company, by the internal committee. All these things come under the law. So now we'll talk about all the details of the law. Before going actually to the law, we'll just talk about gender sensitization. Just quickly, let's see applicability of the law. Law is applicable for all over India. It applies to all the companies, whether it is a small scale company, large scale company. It has less number of employees, it has more number of employees, it is unorganized sector, organized sector, it is a hotel, it is a museum, it is a restaurant. Everywhere this law is applicable. I'm not getting your question, sir. How to apply? We are going to talk about the application, how to apply, what are the processes to be followed by the company or individuals. All these things we are going to talk about in the session. Applicability means this law is binding on each and every company or each and every organization that works in India. So this is what applicability means. You'll come to know about details when we move ahead in the session. Okay. So legal status, like I said, if it is an unorganized sector, there also this law applies. For example, if a maid that comes at her house for housework, if she is being harassed, she also can file complaint under POSH law. How that complaint needs to be filed and all, we are going to discuss later. So let's first talk about gender equality. Gender equality is obviously fundamental right of every individual, but unfortunately, this right is not being provided to women. As we know, they are kept at the backside somewhere. They are not given equal rights. They are not given equal opportunities. So sensitization of people, sensitization of coming generations, sensitization of existing generations needs to be done so that women are treated equally at workplaces, at home, and everywhere. Same rights, resources, and opportunities should be available to everyone irrespective of gender. So this is all about gender equality. Gender equality is a general subject, so I'm not going to spend more time on this topic. We'll straight away move to the law. So we'll now first understand a few definitions that are given in the law. First important definition is an aggrieved woman. Who is an aggrieved woman? What do you mean by an aggrieved woman? As per law, in relation to workplace, a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent. Respondent means the person who harasses a woman. In relation to a dwelling place or house, a woman of any age who is employed in such a dwelling place or house. So these are the definitions. I'm reading out the definitions because these are the exact words mentioned in the law. So what does this mean? Now we'll discuss what it means. A woman working as a domestic worker, as a temporary employee, as an apprentice, as an ad hoc, as a regular employee, voluntary working or with wages. I mean, if she's taking salary or she's voluntarily working without salary, if she's on contract, if she's a trainee, direct employed through some contractor or through some agent, all these you're going to get the presentation PDF in your mails after the session, I mean by Monday. So you don't need to worry about that. All the things that I'm showing you on the presentation right now will be mailed to you on Monday, along with session recording. So be patient with that. So this is what an aggrieved woman means. Now next definition is workplace. What is considered as workplace? When we talk about workplace, when we talk about office, what comes to our mind first? We are going to some place which is called office. There are 4 walls and we all sit in the office for a few hours. We go back to home. So that is called a workplace. But as per law, workplace has a broader definition. What that definition is, let's see. Any government, semi-government, PSU, corporation, institute, any place where people work, any private sector organization, foreign company having their office in India. If a company is an MNC which is not established in India, it is a foreign company, but it has office in India. So the office that is in India is comes under POSH law. Hospitals, nursing homes, sports institutes, sports complexes, stadiums, any place visited by employee arising out of or during employment. If a lady works in media and she is traveling to cover some news with her colleague, and if she is being harassed, that place is also called a workplace. So workplace where a woman is out for work, or otherwise with a person she is having a working relationship. Like I said, she's traveling with some colleague for some official work. Workplace the law doesn't restrict the definition of workplace to the 4 walls of office. And like we all know, after COVID, electronic communication, working from home, this is a new thing that has started after COVID especially. So if if a woman is working from home and she's in a meeting with her colleague discussing some official things, and that colleague passes some remarks which have sexual flavor, that also comes under POSH law. She can file a complaint under POSH law for such an incident. Maybe there is a possibility that you are not understanding 100% of what I'm saying right now. But as we move ahead in the session, you'll be getting more clarity about what all these things are. Okay. So third important definition is what is called sexual harassment. Sexual harassment doesn't actually only mean so sexual harassment doesn't only mean physical touch or being harassed by holding someone or being physically touched. That only doesn't come under sexual harassment. There is a broad definition of it. Physical contact and advance is obviously a sexual harassment, but a demand or request for sexual favors. If a boss is asking for sexual favors from his subordinate or from his colleague, that also comes under sexual harassment. Sexually colored remarks, uh, passing remarks on specific body parts of a woman in front of everyone or in private during working hours or during the working relationship. This is covered as sexual harassment under this law. Showing pornography is also punishable as sexual harassment under the law. Any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. If a woman thinks that what a person has behaved has sexual flavor, has sexual uh, conduct, or is sexually biased, then she can file a complaint. So, any action, gesture, word that has sexual flavor amounts to sexual harassment. The actions that make a female uncomfortable. This is a very important thing that has been mentioned in the law. The feeling of complainant is important. What the woman feels is important. The impact is important, not the intention. If a person says, if a lady complains about some against some person to the committee or to the employer, and that person says, my intention was not to sexually harass her, I was just casually commenting about something. So that kind of explanation will not be granted, will not be allowed if the woman says that she found it to be sexually colored remark. So impact is important, not the intention. Of welcome behavior, unwelcome behavior, this will be solely decided by the woman. If she's okay with it, if she's not okay with it, if is she reciprocating it or she's not reciprocating it, it entirely depends on how the woman perceives the behavior of the other person. Okay, we are good to go ahead. If anyone has anything to comment or anything to ask till now, you can, or else we'll go ahead. You can ask in chat box, you can unmute and ask, whichever way is preferable. Okay, so I consider it to be a yes and we'll move ahead. Okay. Now, what is considered as sexual harassment? Promise of preferential treatment in employment. I will promote you if you spend some time with me or if you come to a dinner date with me. This kind of a statement or this kind of a suggestion or this kind of a agreement that someone wants to do with a lady, it can come under sexual harassment. Threat of decremental treatment. I will throw you out of my team if you don't do this for me. Implied explicit threat about present or future employment status. I will make sure that Nobody will give you work and I'll throw you out of the company if you don't do this for me. Interference with work or creating an intimidating or hostile work environment. Constantly gossiping, constantly passing remarks about someone's body parts, someone's walking style, someone's dressing style. These kind of behaviors come under sexual harassment. Humiliating treatment likely to affect health or safety of the woman. Constantly being targeted by using inappropriate sexually colored remarks or such kind of words comes under sexual harassment. So are we okay till this point? Anyone wants to ask anything? Like I said, we are yet to cover a lot of things. So obviously things will be clear. But if anyone wants to ask anything till now, you are free to ask or give me a good to go ahead. Okay, fine, whatever in chat so that I understand that you're understanding what I'm saying. These virtual sessions have this minus point, I would say. I'm not able to see anyone. I'm just talking to myself. So unless and until you all respond, I'll have to just assume that, okay, thank you, thank you, thank you. Okay, so let's move ahead. Now I want you all to participate because we are going to discuss 3 case studies based on the things that I have explained till now. Try to analyze these situations and try to answer whether this situation, this incident comes under POSH law or not. And I want participation from everyone. You can unmute and talk. If you're not comfortable unmuting and talking, you can write in chat box. But please participate. It's for good of our team as well as for your better understanding. So a woman goes to reimbursement department for reimbursement of some medical expenses. The medical expenses were related to her infertility treatment. Her boss or the person who was supposed to analyze or take care of the reimbursement of bills, he talked about her sex life. He asked questions about how her married life is going. He tried to ask about the details of the process. He tried to give advices about how to get pregnant, how to solve this infertility issue. So do you think this behavior of the person comes under sexual harassment or no? Yes, this will come under sexual harassment because this kind of advice was not required to be given. These kind of questions were not required to be asked. So the lady can file a complaint under POSH law for this behavior. Ajay ji, Vishakha versus Rajasthan case. If time permits, I'll talk about it at the end of the session because we have a lot of things to cover till now, and there is a lot of material available on internet on this topic. So if you want, you can just Google, or else I'll just try to brief at the end of the session. Yes, this was the case which was responsible or which was the base of starting this law or thinking of implementing such kind of a law. So we'll move to next case study. One girl invited few of her friends, or sorry, colleagues at her home for birthday party. Two girls, two females, and three male colleagues went to her place. One of the male colleagues tried to touch other female colleague inappropriately during the party. That girl pushed him and he had injury. Next day, the girl who was touched inappropriately, she contacted the HR and tried to explain the case and filed a complaint under POSH. The man who was injured, he also went to HR. The man who was injured also approached HR and filed a complaint against the girl for injury, for causing injury to him. So, will this case come under POSH or no? Anyone wants to unmute and reply why this comes under POSH or why not? Okay. So, most of you have said yes here. Now, let me just bring your attention to few important points under the law. First thing, there has to be a working relationship, there has to be a workplace, and there has to be a woman. These three W's are important under POSH law. Working relationship, workplace, and woman. Obviously, the law is for women, so women is obvious, but other two things, workplace and working relationship. Now, although these people were colleagues, were they at an official party or they were at a personal party? This was a personal party. This was not an official party. So, although there is a woman involved, there is a working relationship between all of them, but there is no workplace. They were together for personal reason and not for official reason. So this case cannot come under POSH law. Obviously, the HR can take action about misconduct or misbehavior, or HR can, warn that person not to behave this way. That can be done, but a complaint under POSH cannot be given under this. In this circumstance. HR can take action. HR can warn that person about behaving well with women, but HR cannot take a complaint under POSH law. If in place of the personal party, this would have been a official gathering, official party organized by the company, and same incidents would have happened there, it would have come under POSH. So I hope this is clear, right? So next, one more case study we are going to talk about now. A big multinational company is headed by a strong and dominating female CEO. She was attracted towards a young, talented male employee of the company working under her. She called him and in her chamber and asked for sexual favors. In turn, offered him promotion with huge jump in salary package. He refused and filed a complaint. So, like I said earlier, the law is basically for prevention of sexual harassment of women at workplace. So this person complaint cannot come under POSH, but he surely can complain to HR. He surely can go to the police and file a complaint of sexual harassment, but it won't come under POSH because POSH says that the aggrieved person or the victim should be a woman. The respondent or the person who is committing the crime or who is committing the sexual harassment can be a man, can be a woman, can be a third gender person, or person or a person of any gender of for that matter. But the victim or the aggrieved person should be a woman. So this case will not come under POSH, but still that fellow can go to the HR. HR should have gender neutral policies for sexual harassment prevention, and HR can take action against the lady under that policy, or that person can even choose to go to the police and file complaint under Indian Penal Code. IPC has a sexual harassment provision of filing sexual harassment. Even a man can file. So that is applicable, but not this situation cannot come under POSH specifically. Okay, so let me take a few questions. We have some questions in the chat. Okay, so if somebody at work behaves okay out of the office, acha. If somebody at works, if somebody behaves okay in the office and outside office that person is harassing, it will come under POSH if that person calls for some work, or continuously they are in touch for some work and in between work that person is harassing. Else what the lady can do is she can go to the HR and give a complaint. The HR can warn that person, and if the harassment continues, HR and the lady can think of going ahead and filing a complaint, getting a complaint registered under POSH. It may or may not come under POSH. There will be a lot of things to be considered. If they are casually chatting about their personal lives and in between the harassment happens or in between he says something inappropriate, that may not be coming under POSH. But if they are talking something about if they are discussing some official work, and during that official work, I mean discussing not just on call, if they are discussing something on WhatsApp, some official thing on WhatsApp, and in between that conversation, if a person passes some sexual remark, that can come under POSH. So the evidence needs to be given. If the conversation or the interaction outside the office is about official work and the harassment happens during that interaction, it will come under POSH. If the interaction outside the office is personal, it will not come under POSH. So I hope I have answered your question, Milind. Let me see if any more questions are there. Okay. Oh, all right. So anyone wants to comment anything till now about the case studies, or anyone wants to share any incidents, or anyone wants to ask anything about, ask any clarification about anything that we have discussed till now? Okay. So we will move ahead now. This statement is very, very, very important. I have already talked about it earlier, few minutes before. The experience of the woman, if she says that this is, I feel that this is sexual harassment, the employer must get the complaint from. The employer cannot deny. Sexual harassment is a subjective experience. Subjective to whom? Subjective to the woman. See, there is a difference of upbringing, there is a difference of openness, there is a difference of culture. When we work together with people coming from different backgrounds, what is okay for someone may not be okay for other. So this needs to be considered and this needs to be kept in mind while behaving with people. Even two identical twins who are brought up by their parents in one single house have different personalities, have different thought processes, have different level of understanding. So just imagine if adults, if people coming from different cultural backgrounds, different social backgrounds, different financial backgrounds, come and work together, it will be a subjective experience for everyone to understand or to know or to judge whether this specific some kind of act, some kind of behavior comes, can be called a sexual harassment or no. For example, a person who is born and brought up in a metro city like Bangalore or Mumbai or Delhi, for that person, hugging a person of opposite gender may be a casual thing, right? But for a person coming from a tier 3 city or coming from a rural background, for that person, even shaking hand with person of opposite gender can be awkward. So if I'm interacting with someone, this is not specifically for a, I'm right now I'm talking about the general thing, not specific to the law. But if I'm interacting with someone, I need to make sure that I am not violating the boundary of the person. Boundary of each individual can be different. So I need to respect boundaries of everyone. So if I am an open person, if I am a very jolly person, I like to mix with people and I casually give hugs to all my colleagues irrespective of gender. And I have no intentions of harassing anyone. But if someone tells me that I don't find it appropriate to be hugged or I don't want to be hugged, I should respect it. Right? So sexual harassment is a subjective experience. If the lady says that sexual harassment has happened, or if the lady says that the behavior of a person, she thinks that the behavior of a person is with sexual color, then it will be acceptable under the law. So now major part, redressal. What the company should do if sexual harassment happens. What does the redressal part of the law says? Okay. When I say sexually colored remark means the sentence or the meaning of the words used has sexual content to it. So what the company should do? Company should make internal committee. Each and every company is bound to have an internal committee mandatory for establishments with employees more than 10. If a company has 11 employees, the company should have internal committee for specifically for sexual harassment, prevention of sexual harassment. It needs to be formed in writing. The members of the internal committee should be informed in writing about being part of the committee. The internal committee needs to submit annual report to the district office every year. If there are no complaints of sexual harassment, there is a form for this annual report. So if there are no sexual harassments during the year, the company or the internal committee should send a blank report. I mean, there are, just put dash 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 on the formats, and but they still have to submit the report. Annual report means does not mean financial year. It means January to December. So in January every year, the company needs to submit. The internal committee needs to give the report to the company, and then the company will submit the report to the district officer. District officer is generally magistrate and collector. So they every company is bound to give this annual report. Now, what does an internal committee mean, and who can be part of internal committee? POSH law says that presiding officer of the internal committee should be a senior lady from the company. Senior doesn't mean senior, it's senior by age. Senior means senior by position. So a lady with a senior position in the company should be presiding officer of the company. Presiding officer of the internal committee. 2 members committed to the cause of women and having experience in social work or law background need to be members. Some NGO social worker who is familiar with the law, who works for women's rights and all. And total number of members should be minimum 4, but the number of members should be 4, but in case of non-agreement between the members, and if in case voting needs to be done, then 4 people will be, if 2 people are on one side and 2 people on other side, the internal committee will not be able to conclude the case. So to have majority decision, it is recommended that the internal committee should have 5 members or members in odd numbers. So there is a question here. If possible, would you be able to describe roles of internal committee members? There are no such roles assigned to them as this person should do this, or the presiding officer should do this, and one member should do this. They don't distribute roles like that. But they work as a team. There is no specific roles assigned to any one of them. They work as a team. There are a few more questions. Internal committee should be all women? No, not at all. There can be men in the committee, but the presiding officer law says that the presiding officer should be a woman. Other members can be male also. If a aggrieved woman is unable to make complaint on account of physical or mental incapability, we are going to talk about this in a few minutes, Ajay. So your query will be answered there. So this is a internal committee structure. Every company should form an internal committee and inform all the employees. There should be boards displayed at different locations inside the company, mentioning the names and for contact numbers, contact details of these members. So, there should be a board saying the committee formed under POSH law. This is the presiding officer. These are the members. These are their contact numbers. These kind of boards should be displayed everywhere in the company. So there is a local committee that is formed by the district office of every district. This is government's part, not the company's part. So this is set up at every district by government. It is the grievance redressal body with respect to organizations which have employees more than 10. The law says that the company which has more than 10 employees should have their own internal committee, and the companies which have less than 10 number of employees, the reporting authority or the complaining authority for them is the local committee. Organizations that have not set up an IC, there are a few organizations who, if an organization doesn't have an internal committee and some sexual harassment happens there, that women can go to the local committee and file her complaint. For domestic workers, like I said, for people who work on daily wages, for housemaids, for all of them, they can approach local committee for a complaint. So how can the aggrieved woman give complaint? First thing is she can obviously go to internal committee or LC, not EC, LC, local committee or internal committee. Sometimes what happens is a woman is scared of going to the internal committee, and she doesn't want to go to the internal committee for for filing her complaint. So she can choose to go to local committee. Within 3 months of the incidents, it is expected that the woman should report the incidents and file a complaint within 3 months. If she doesn't want to go to the internal committee as well as to the local committee, she can file a complaint online at shebox.nic.in. This is a website owned by government, Ministry of Women and Child Development. And after the complaint goes to them, they send the complaint below down, and it is followed up by government authorities. Sorry, there is a mistake here. It is not EC, it is LC. This part, it is EC. Sorry, it is LC and not EC. I have written this wrongly. Internal committee or LC, local committee, IC or LC. I have written it wrongly. I have to change it. Okay. Yeah. So let's move to next part. So what should be the complaint? How should be the complaint? Date. What is how the complaint? What will be the parts of the complaint? The date of the incidents, working relationship with the respondent, name of the respondent as well as name of the lady, time of the incidents. So all these things needs to be mentioned. There is no specific format or form for this. The lady can give a complaint on a plain piece of paper, a written complaint. That works. EC doesn't mean external committee. There is nothing called external committee. There is just local committee and internal committee. Internal committee is inside the company, and local committee is formed by government officials at every district. So there was a typing mistake in the previous slide where I had written EC. Anybody can bypass EC if they don't want to go to the, sorry, not EC. Anybody can bypass internal committee and directly go to the local committee, or they can directly even go to the, let me show you the previous slide. If I don't want to go to the internal committee, or if I don't want to go to the local committee, I can directly file my complaint online on shebox.nic.in. All the complaints received on this portal are monitored by central government officials of Ministry of Women and Child Development, MWCD. They monitor all the complaints received here. So if someone is not comfortable giving complaint at IC or at internal committee or at local committee, they can directly file a complaint here. Okay. Yeah. So these are the contents of complaint. Next thing is in case of incapacity of women. So Ajay, you asked this question. Ajay, your queries are going to be answered in coming part. Ajay पहले से ही questions पूछ रहे हैं. False और malicious complaint के लिए क्या है punishment? We'll talk about it at the end of the, I mean, in few more minutes, Ajay. पहले answer of your previous question. In case of incapacity of women, if a woman is not able to give the complaint because of any reason, if she is not physically fit to go and file a complaint, if she is not mentally fit to go and file a complaint, if the woman who was harassed is dead, she is not alive, or if there is any other reason, in that case, complaint can be filed by a relative, by a friend, by a co-worker, by a guardian, by a person having knowledge of the incidents. A third person who is not at all related to the woman, but he understands or he knows the case also can file a complaint. If the complainant, if the aggrieved woman is alive, consent from her is needed for filing the complaint. If the woman is not alive, consent of her family members is needed to file a complaint. So a woman need not file the complaint by herself. If she is physically incapable, if she is injured and she is not able to go and file the complaint herself, or if she is mentally traumatized and she doesn't want to go, if the complainant is not, if the aggrieved woman is not alive, or for any other reason, anyone who knows about the incidents can file a complaint with her consent. And in case of death of complainant, consent of a family member is needed for filing. Okay. So there are some NGOs who work for women empowerment. Even such NGOs file complaint on behalf of the lady. They, fight the complaints, fight the cases, and on behalf of the lady, provided the lady gives consent for filing the complaint. Now, grievance redressal process. When the complaint comes to internal committee, what the internal committee will do? Pallavi, you had asked about specific roles of internal committee members. So like I had said, there are no specific roles, but what the internal committee should do or what the internal committee does, we'll discuss that now. Yes, Ajay, legal hair friend can make a complaint. That's what I said. Any friend, any relative, any legal hair, anyone who knows about the incidents can file a complaint. Okay, so incidents of sexual harassment has happened. If the time period is less than 3 months, the complaint will go to the internal committee or local committee. If the time is more than 3 months, the lady should mention reason for delay of filing the complaint. She should give the reason in writing for the delay of filing the complaint. Then the complaint goes to internal committee. The internal committee will work on settlement or conciliation of the case. This is not at all mandatory, but for fast working or for solving the case early, this settlement part can be done. Settlement doesn't mean bribing some person or uh, forcing someone to take the complaint back or forcing someone to accept the allegations. Settlement does not mean that. Settlement means both the parties involved are come to a conclusion that this has happened, and this is the what you say compensation we are going to give, and the respondent or the person who has committed the crime will say that yes, I will not repeat this behavior. This is called settlement. So internal committee will record the settlement on paper and forward it to local committee and to both the people involved, and then there will be no further inquiry. If any of the party, uh, um, any of the persons involved do not agree for settlement, then there will be an inquiry. In inquiry, there will be evidence checking. The persons will have to provide proofs. The persons will have to bring evidences if the harassment has happened in front of some colleagues. So the lady can request them to be present in front of the internal committee and give the facts. So this is the process. Then next thing is inquiry process is followed, like I said. Then the inquiry report needs to be submitted to the employer and the parties. The internal committee will give their recommendations or the findings or the result to the employer and to both the people involved. If allegations are proved within 30 days, the company should take action according to the service rules of the company. Monetary penalty should be given to the aggrieved woman. If allegations are proved, this needs to be done by the company within 30 days of getting report from the internal committee. If allegations are not proved, no action to be taken. Assessment of whether the charges were false. If the woman purposefully filed a false complaint to malign the image of a person or to harass a person, so, and the allegation is not proved or the allegation is found to be false, then no action will be taken against the person, against the man. But internal committee will inquire whether this was done purposefully by the woman or it was just, general misunderstanding kind of thing. If the malicious intention of the lady is proved, then she will be punished. What is the punishment? We'll talk about it in a few minutes. So this grievance redressal process is okay. This is clear what the internal committee actually does. I'll just sum it up. When the internal committee receives the complaint, if it is within 30 days, they will accept it. If it is more than 3 months, if it is the incidence is within 3 months, the internal committee will accept it. If it is beyond 3 months, the person who is giving the complaint should give a written reason about the delay in filing the complaint. Then after receiving the complaint, the internal committee will talk about reconciliation or settlement between both the parties or between both the persons involved. If the settlement happens, the case closes there. If the settlement doesn't happen, the internal committee will go ahead with the inquiry. They will examine the proofs, they will examine the evidences, and then they will come to a conclusion. After the internal committee comes to a conclusion, they will forward the conclusion to the employer as well as to both the people involved. And after receiving this conclusion, the company is supposed to take action within 30 days. The action needs to be taken according to the considering the recommendations of internal committee and the service rules. Monetary penalty can be decided based upon the level of harassment, medical expenses involved and all. We'll talk about it in a few minutes. And if the allegations are not proved, there will be no action against the man or the respondent, but The internal committee will further examine if the allegations were just a misunderstanding or they were done with a purpose to malign the image of the respondent. So during the process of inquiry, before internal committee comes to a conclusion, between the part of receiving the complaint and giving a decision, this part, if the lady says that I will not be able to work in the same office with this person till there is a judgment or there is a conclusion, during the pendency of the inquiry, if the aggrieved employee or the aggrieved woman gives a written request to the internal committee, she can be given transfer, or the respondent will be transferred, or she will be granted leave up to 3 months. These are the provisions of the law. So during the pendency of the inquiry, during the period the inquiry is going on, if the woman says that she will not be able to attend the office, there is a provision under the law that the employer must grant her a leave if she applies for it in return. Or if she in return says that I will not be able to work in this office, either she should be transferred to other office or the person should be transferred to other office. If not other office, other department. So if they are working together in same department, then their departments should be, they should be transferred to different departments. This is the mandatory provision that the employer and the internal committee should take care of if a woman gives them a written application, written request. So compensation, how the compensation is determined? What are the factors that need to be considered while coming to some amount for compensation? First thing is mental trauma or pain that is caused, loss in career opportunities, medical expenses if there are any, income and financial status of the respondent, the person against whom these allegations are made, and if the allegations are proved. All these things are considered while calculating or while determining the compensation to be provided to the victim. Okay. It can be in lump sum or it can be in installments. Now, after the internal committee comes to a conclusion and either of the parties involved, either of the people involved are not satisfied with the conclusion or the judgment or the result of the internal committee, they can file a complaint. They can go to the court and file a complaint. So after receiving the result copy from the internal committee, any of the parties involved can go to the court and file a complaint, or they can approach court and file a case within 90 days of receiving the letter or receiving the recommendations from the internal committee. So there is a possibility of not agreeing or not accepting the recommendations or the result of the internal. Now, we are coming to your other question, Ajay. Punishment for women. If a woman is proved to be guilty of filing the complaint with some malicious intention, her intention was only to malign the image of the person or to harass him. If this is proved, the internal committee may recommend the employer to take action against the woman as per their service rules. But monetary compensation for respondent is not applicable here. I mean, even if the woman has done it there is no sexual harassment involved and woman has done it purposefully just to harass the respondent. In that case also, there is no provision of monetary benefit or monetary compensation to the respondent, but the internal committee can recommend the company to take action against the woman as per their service rules. So these are some timelines. Like I said, you'll be getting this presentation, so these timelines will be available to you. Within how many days the complaint should be given, within how many days the person should respond. All these things are mentioned in this timeline. Most of the things I have covered. And these are very easy to read, so there's no, much explanation required here. So now what the employer should do? What are the obligations of employer under the law? How the employer can work towards creating a safe working environment for women. Like I said earlier, internal committee members' names should be displayed. Penal consequences, that is the consequences as per law for the sexual harassment, this should be displayed. IC should be, internal committee should be formed. Grievance redressal mechanism should be made available. Awareness sessions are mandatory as per law. The POSH law says that the company should conduct POSH awareness sessions every year for all the employees for their sensitization. Orientation programs for internal committee members. Obviously, the internal committee members may not be aware of how to process the inquiry, how to work on it, how to write a report. So capacity building of internal committee members should be organized by the company. This is also a responsibility of the company. Creating safe environment, creating an anti-sexual harassment policy. Every company must formulate an anti-sexual harassment policy, and it is recommended that this anti-sexual harassment policy should be gender neutral. Although POSH is, we can say, gender biased because it is only for women, and there is a reason for it, obviously, but the anti-sexual harassment policy can be gender neutral. What else the company needs to do? Cooperate and assist during the course of inquiry. If the respondent or if the person who has committed the sexual harassment is an influential person of the company, inside the company, the management should be, ready enough to support the unbiased inquiry and support the aggrieved woman. Treat sexual harassment as misconduct under service rules. Provide assistance to aggrieved women, like we discussed it earlier. If she wants to go and file a police complaint, it's a duty of the employer to assist her in doing that. The employer should file complaint, go to the police and file complaint, file FIR under IPC. Then it is employer's responsibility to submit yearly reports to the district officer. If the employer fails to do so, there are penalties as per law. If an employer is not forming internal committee, or if they are not for submitting reports, or if they are not conducting inquiries even after receiving report, or if they fail to complete the inquiries within given deadlines, there can be fine that will be levied on them, and this judgment or this assessment is done by the district officer. So this is all from my side. If